Hello and welcome to RSTV TV, watching the big picture with the host Rajat Kane. In this edition of the show, we'll discuss the issue of regulating the content of online streaming platforms. The Supreme Court bench led by Chief Justice of India Ranjan Gogoi has sought government's response on a petition challenging for regulation of content on online streaming platforms such as Netflix and Amazon Prime. As reported by news portal Bar and Bench, the PIL, which was earlier dismissed by Delhi High Court, is seeking formulation of guidelines for the regulation of content on online streaming platforms, besides claiming that said platforms are not only displaying unlicensed, unregulated and uncertified content, but also running without being governed by any guidelines. The plea also claims that due to lack or absence of any guidelines to govern the online platforms, government agencies are creating a special class of broadcasters and discriminating against customers, cable TV operators, producers and D2H operators. Now, how far can the content of such platforms be regulated? What does the law say? To discuss more on this issue, we're joined by Harpreet Singh Hora, Advocate Supreme Court, Pawan Duggal, cyber law expert, and Abhishek Mehrotra, Executive Editor, Samachar for Media. Thank you all of you for joining us. Harpreet Singh Hora, I would like to start with you first, since it's your petition. I understand there are two parallel demands. Could you, for our viewers, explain what exactly you are seeking in your PIL?
See, this issue had started initially from an RTI the petitioner had filed asking two questions. Firstly, that who's the licensing authority for these online platforms? And secondly, what are the regulations which are applicable on these? Now, those two questions were replied by the ministry in a manner for the reply to the first question that said that they are not aware of the licensing authority, which itself is a big shocker at first place. Secondly, as far as the regulations or law or bylaws governing that, it had reproduced section 79 of the IT Act.
Okay.
Now, if you'd see section 79 of IT Act is only applicable to intermediaries. So these online platforms cannot be termed as an intermediary at first place. This was our initial argument on which we have started drafting this petition when we had filed it in the Delhi High Court. Down the line, when the response was sought from the ministry in the Delhi High Court, we had discovered, because the ministry had admitted on an affidavit that these platforms are actually unlicensed for the reason that the ministry says they do not need a license.
Right.
This itself is a shocking fact for that matter. Secondly, now when we talk about regulations, anything in a country like India, because we do not have an absolute right, even if we talk about freedom of speech and expression, we do not have any absolute right for that matter. It always comes with a reasonable restriction under 19(2) of the Constitution of India. So if you say they are not regulated by any regulatory body, it means you are one or the other way trying to transcend the boundaries of Article 19(2) of the Constitution. Thirdly, when we talk about discrimination between the regular movies and these movies streamed on these platforms, the point that comes to the fore is that those movies are certified by the CBFC, which ultimately is governed by the Cinematography Act, which again has to be under the parameters as laid down by the Constitution. Now, these platforms have been given a free run that even if you if you telecast a movie which carries the CBFC certificate or it does not carry, that won't matter. You can broadcast that movie. So, in a manner, you are indirectly trying to bypass the law. This is how this petition has come to the fore. When the final decision was given by the Delhi High Court on 8th of February, the Delhi High Court was not convinced by our arguments, and it had laid stress on the provisions in the Information Technology Act, because the ministry says that we do not have a mechanism to govern those online platforms. Although if the content contravenes certain sections of IT Act, the petitioners have a remedy to which they can avail for those contraventions. Now, our basic concern is that those contraventions are post-screening, or those remedies can only be availed post-screening. If we already have laws which are pre-screening as well, why not we have those laws for these streaming platforms as well? Because as I said, there is no absolute right. There is only a qualified right under the Constitution.
Right. Mr. Duggal, first up, is there a regulation mechanism for such an online streaming platforms?
Currently, as of this afternoon when I'm talking, there are no regulatory mechanisms in the country yet. However, The fact remains is that almost all these online streaming platforms qualify as intermediaries, and that's crystal clear when one reads to the definition under Section 21W of the Information Technology Act. Because these online streaming platforms are legal entities who on behalf of other persons are receiving, storing or transmitting electronic records or providing with service with respect to electronic records. And further, because they provide these services on a network, they become network service providers and hence get fully qualified as intermediaries. Once they are intermediaries, under Section 79(2)(c) of the IT Act, they are mandated to exercise due diligence. Various parameters of due diligence have been defined by the Government of India in the Information Technology Rules 2011, but none of these parameters of due diligence have specifically been drafted or elaborated, keeping in mind the peculiar requirements or the peculiar business operations of online streaming platforms. So today, there is no such due diligence mechanisms. The ball is in the court of the government. The government ought to have done this. Otherwise, how can you actually explain that nudity, frontal nudity, which is completely prohibited under the Cinematographic Act, actually gets trickled in through these online streaming platforms to various of their web movies or web serials. So I think that the fundamental rule is no one can say I am totally unregulated. Yes, you are on the internet. That actually does not mean that you have a license to go ahead and violate the fundamental provisions and the basic structure of the Constitution. But I think the lacuna here is lying in lack of imagination on the side of the government to come up with adequate enabling legal frameworks and specifically parameters for due diligence for these kinds of online service providers.
Abhishek, we heard about the legal side of it. We heard about the law side of it. Do you think that there is a requirement at all to regulate, or internet by itself means self-regulation? It's your choice. You want to read it, you want to see it, you want to hear it.
I will take this forward to also on the online contents. When we are talking about the streaming platform, we should also contend about the news portals also. The confusion is that they doesn't come in under the MIB, they come under the telecom. Once Rathore has also said that they can't regularize or they can't do anything with the news portals also, which are providing online content. So I have to say that first the government has to take the decision to have this online contents under the license process, because in lack of any license, there are no way to solve this issue.
Right. Mr. Hora, I mean, as you move to Supreme Court, what is addition to your prayer? Have you annexed anything? Now, if we consider part of a petition which talks about regulation on grounds of obscene content, as you have said, is there any annexures that you produce before Supreme Court that so-and-so platform is trickling in nudity, or for that matter, any obscene things which has to be certified and only then it can go to public domain?
See, when we talk about the content being obscene, now obscenity is one of the portions of the content, inappropriate content. We have also talked about, now if you will see the parameters which are already applicable to regular movies, violence is also one of those aspects as far as content is concerned. Now the part as far as annexures are concerned, we had annexed certain scenes from certain specific shows when we filed it in Delhi High Court. But content is only fourth parameter of our petition, because see, when we talk about content, I'll be very honest with you, that is very subjective. Something which you could be inappropriate for you might not be inappropriate for me. I'm a 26-year-old adult man living in a democratic country, right? Something which I am allowed to view in public space, I might be okay with it, you might not be okay with it, and this is very subjective. First three aspects of the petition are very objective. Whether they have a license, yes or no. Whether they have any regulation, yes or no. Whether they have certification, yes or no. And moreover, now you would also have to take note of the fact that the regular movies, the regular broadcasters are also carry a grievance portal with them. Whether these, because for everything I cannot go and file an FIR. We also have to have preventive laws for that matter. You cannot say that two cars have collided and you have to go and file an FIR because you have a remedy under IPC. For that you have Motor Vehicle Act as well, which means it is a preventive measure. For that matter, the inappropriate content is very subjective. Firstly, we also have to deal with the objective parts of these online platforms. Only then we can get onto the subjective part of these content, of these platforms.
Right. Mr. Duggal, it's been a long debate whether internet or online content can be regulated. Sometimes it's also called as a regulation of internet oxymoron. Is it practically possible? As I asked Abhishek, he runs a news portal. He's executive editor of a news portal. It's up to discretion. When anything is there on the internet, it's up to your discretion. So can that discretion per se be regulated? You can't see that or you can't hear that.
I think internet has been typically as a paradigm beyond regulation. And the internet has made geography history, and that allows various platform providers and service providers to be in different jurisdictions while giving their services to other people located in other jurisdictions. However, that's what was the thought process a decade back. Things are now dramatically changing as far as the cyber law jurisprudential landscape is coming up. More and more countries are now waking up to the need for regulating such kind of content and the conduct concerning the content within their physical, geographical boundaries. So no wonder we are now beginning to see countries like Russia coming up with data localization laws, saying your local laws must be actually complied with, even in terms of your content, and the content must be locally stored and actually be preserved. Now you look at the Chinese laws and you say, well, they are specifically saying you may be located anywhere. If your services, if your content is available on computer systems or networks in China, you have to comply with local laws. I think that's what the growing paradigm is, and I think the Information Technology Act 2000, being the Indian cyber law, has actually echoed this position, not now, almost 20 years back when it got passed in the year 2000. Now that at very time, they had actually inserted Section 75 and Section 1 under the IT Act, which categorically said that the Information Technology Act 2000 is applicable to any person of any nationality, anywhere in the world, so long as the impact of such services are available or felt on computers, computer systems or computer networks physically located in India. So though it actually provides for extraterritorial jurisdiction, the fact remains is we as a nation have been completely unsuccessful in going ahead and implementing this extraterritorial jurisdiction. Having now said that, quickly realize the nature of the debate is changing. Governments are saying now is the new age of cyber sovereignty. I need to protect and preserve my cyber sovereignty, and as an integral part of those strategies, I want service providers to actually comply with my local laws. So in a scenario like this, there's nothing stopping the government from telling these online streaming platforms, wherever you are, we don't bother. If your content or services are available on mobiles or computers in India, then you will have to comply with the parameters of local Indian laws. But unfortunately, we haven't gone that far ahead yet. We are in a state of conundrum. We are undecided, and that's why these kinds of new debates are coming in, and that's why hopefully this public interest in litigation before the Supreme Court should try to settle this issue once and for all. I'm very clear. These guys are intermediaries. They can't run away from the law. Existing law, however deficient it is, you will have to comply, being the Information Technology Act, the rules and regulations, being the Cinematographics Act. You don't want to comply, well, you can wait for some grey area while the government gets its act together. But once the government decides that it has to implement the law, there will not be much scope for negotiation. So the quicker this industry self-regulates on its own and comes back to the government to say, sir, we know there's no law, we know there's no legal regime, but as a part of good corporate governance, as a part of our service to your country, we are on our own coming up with a voluntary self-regulatory code of conduct, and we like to abide by it. If that kind of an approach gets coming in, then to a large extent, the government may not be moving forward in the direction of legislating in this space. But in case, if this kind of content comes up and people's, shall I say, sensitivities are going to be potentially disturbed or prejudicially impacted, I see no reason why such kind of regulation or legislative measures don't come in the coming times.
Right. Abhishek, on daily basis, when you publish your stories on news portals, do you find grey areas, or there is a larger mechanism within these online news portals to self-regulate?
हाँ, मुझे लगता है कि जिस तरह से हमारी टीवी इंडस्ट्री ने पिछले 2 दशकों में अपने आप को सेल्फ रेगुलेट किया, हम देखते हैं कि तमाम जो आतंकी गतिविधियाँ थी, जब पहले मुंबई हुआ उसके बाद से हमने किस तरह से अपने मुझे लगता है ये वो दौर है जब जैसे पवन जी ने कहा कि सेल्फ रेगुलेशन इज द बेस्ट थिंग. वी हैव टू गो फॉर द सेल्फ रेगुलेशन बिकॉज इफ गवर्नमेंट ट्राई टू रेगुलेट अस then it will take some mistakes, it will make some confusions about the things, it will be the art on the expressions of action. So the thing is, what I feel, the self regulation is the best thing, and the people coming to them and the industry has to take action from inner self only.
Right. Harpreet, the other part of your petition, as reported by several portals and news website, is that you claiming that due to lack of absence of any guidelines to govern the online platform, government agencies are creating a special class of broadcasters and discriminating against customers, cable TV producers and D2H operators. Could you elucidate on that point?
Yes, I'd tell you how is that. When we say that you are creating a separate class for these online platforms, what I intend to convey is, for example, Mr. X is a regular movie producer. He has produced a particular film. For that, pre-screening, that would go to the CBFC.
Okay.
The CBFC would give the modifications, for example, from minute 121 to minute 123. So XYZ are the objections. It would be sent back to the producer or to the director or to the competent authority. They would have to carry out the modifications or convince the CBFC that how either we are modifying that or we are not violating the law. They would get a particular certificate because there are categories of certifications by the CBFC. Only then they would be allowed to go ahead with the movie. Now the cable TV operators, or for that matter the D2H operators, even they are bound by law. There is a regulation for that matter. Now let us say the same movie producer who's even let's say is based in Mumbai does not want to comply with this formality, let's say, or law in strict sense of CBFC. All that he needs to do is to bypass the formality of CBFC, or in strict sense I'd say the law of the land, has to rope in any online streaming platform and get that movie telecasted. You cannot stop him either way, right? So this obviously is a category which you have created specifically that if you want special treatment, you want to bypass the law, you have a particular way out for that. It means you are violating the equality clause as well. I am based out of Mumbai, my friend is based out of Mumbai, I am producing a movie, he is producing the same movie, I am not allowed to telecast that, he is allowed to telecast that. This is a clear violation of equality for that matter as well. So this loophole is being exploited.
Well, that's fairly difficult because making a movie requires a lot of money and all, and that for that every producer would rather prefer to have it released in the cinema hall. Mr. Duggal, I mean, so by and large it means that since you're having a regulated movie screening in cinema hall, we should also have a similar regulation on whatever that comes to TV or whatever that we're able to see in a private space.
I actually think while this idea looks very, very attractive, in ground reality, implementing the idea will be a very tall challenge. Primarily because people can be physically located outside your territorial boundaries and they say, I'm not bothered about your law. I will continue to host it on platforms, on servers, physically located outside your country. Do what you can. Best that you can do is you can allow such kind of a content to be not displayed in the country by means of a blocking order. But then blocking order being notoriously ineffective, there are so many indirect ways of trying to reach up to the blocked content thanks to various free tools that are available online. So I think it is a culmination of various factors that are coming to the forefront. Number one, a growing realization that yes, this is one space that the governments are increasingly coming in. So before they come in, let's try to lock them out by saying we are doing self-regulation. Number two, if you're going to take head-on the existing legal frameworks in a country, and they say, I don't bother about your frameworks, I will do what I want to do online, you could potentially do for some time. But then the government will have all the powers in the country to try to block your respective content. I think over a period of time, it will ultimately depend upon the maturity levels of people. People will have to quickly realize if they're in for the long haul, then they better well comply with the legal frameworks, whatever minimal they are. But in case you want to be just a fly-by-night operator, or you want to be a Tom, Dick and Harry on a darknet website and you don't care about the law, that's also an option to you. But I believe increasingly more and more governments would be inclined for regulating online streaming of content.
I'll just come to you, Abhishek. Harpreet, I mean, given like the connective thing, when the matter was heard before the Delhi High Court, the Ministry of Law and Justice, they in the submission, they said that this matter is not under the purview. What exactly they meant when they say that this particular issue of guideline for the online streaming portal is not under their purview?
Is this off the record you're asking?
No.
I'll tell you. So what had happened in the court, I'll tell you, because this is not reflected in the order and this is a very technical question.
It's reported. You can also skip it, yeah. It's reported there.
So what had happened, the opposing counsel had submitted that Ministry of Law and Justice has nothing to take with the matter because that was also one of those parties. Now our prayer too in the petition in Delhi High Court was that either the court can come up with guidelines, for example in Vishakha, because we had quoted the example of Vishakha, the Vishakha case, which says that in case of absence of any particular legislative framework, the court can step in and form general guidelines for that matter. So it said that either the court can come up till the time there is a legislative lacuna, or the Ministry of Law could be, the legislative department of theirs could be directed to frame particular piece of legislation for regulating that. Now, the opposing counsel had submitted that for that matter, only on that aspect, that we are not able to understand why they have made the legislative department as a party. So this was our answer to that question, that they have to be a party because what we are particularly intending at is the formation of a legislation or the guidelines. The guidelines would come from the court. Obviously, the legislation has to come from the Ministry of Law. So this was our point as far as making them as a party was concerned.
What was Centre's submission to your PIL in Delhi High Court?
Centre's submission on papers, it was that they do not require a license, and that is the reason.
You mean the online streaming platform doesn't require license?
Yes.
Okay.
Secondly, the MEITY, the department for which the comments were sought on this petition from that department as well, they had said that post-screening remedies, which I had already mentioned, that are available to the petitioners for that matter. Now, my point is that if you say you do not have a mechanism, because my friend from the other side of the fence had mentioned that this is a new phenomena and till that time they do not have a provision for the licensing. And he is absolutely right as far as the technical point in law is concerned. Now, my point is, I would be very honest with you, do not see this petition as a hostile petition. What we are seeking is the evolution of law. For example, 200 years ago, you might not have had a law on motor vehicles, the cars which run on petrol or diesel.
Right.
50 years ago, you might not have had a law on electrical cars or buses in India, in Delhi, let's say. Now you have driverless cars coming up as well, let's say in Europe or maybe in India as well. 5 years, 10 years down the line, you would have to have a mechanism for driverless cars as well. You cannot come up and say we do not have a mechanism for driverless cars, hence we cannot allow them in India. You have to get a mechanism today or 10 years down the line. You do not have evolved space law in India today. 5 years down the line, I might go to a college for a lecture and somebody might ask me a question on space law. You need to have a mechanism, and that is the prerogative of the legislature itself.
Right.
We are not asking the court to cross that line, because that would be another debate altogether.
Sure.
So we are not asking for overreaching. All that we are asking is that we as a concerned citizen are also seeking the evolution of law. This is what we intend to do with this.
Abhishek, briefly, do you envisage a scenario in times to come that we see more and more such debates on regulation of not just the news portals, but also online streaming platforms or other things that are there on the internet?
Definitely, as the time is going on and the internet is on mobile on every palm, the debate will continue, and I think that there should be a regulation, but that I just said before, the regulation should be a self-regulation, not any imposed regulation on the online streaming.
Mr. Duggal, now this is fairly important thing. Space which is so dynamic, space that changes, that adds so many elements after every, say, interval. How difficult or possible it is to have any law that would be rather more hypothetical, or for that matter, I mean, presumptive?
That's a problem in the constant challenge and struggle between law and technology. Technology is invariably 10 steps ahead of law. And also brilliant our legal drafting skills are, the fact still remains is, as lawmakers, you do not have the ability to predict how technology will start working. But increasingly, there's now a trend for encouraging lawmakers and decision makers to come up with more broad, generic, futuristic looking legal provisions so that they can actually stand the test of particular time. Now, the technologies that are currently moving on are remarkable. We have artificial intelligence coming in a big way.
Right.
A quantum computer is coming. We have blockchain. We have IoT. In a scenario like this, there's now a need for the classical policy maker or the policy drafter to come out of his classical mindset, adapt himself to new ground realities, and start coming up with futuristic rules. Just to give an example, 2 weeks back, China has now come up with the world's first law on artificial intelligence. California has come up with a new law on regulating cybersecurity in the context of Internet of Things. So I think these are trailblazers, and we'll have to take inspiration and example from these trailblazers and start coming up with more enabling frameworks.
Right, right. Thank you, gentlemen. I'm sorry you have to wrap it up here. Time is less, but it's a big debate whether any content that is in the purview of Internet, in the public, can be regulated or not. I mean, as we say, the opinions seems to be divided, but it's an important debate nonetheless. Thank you for watching Big Picture.